and I'll just admit people as they come in. Good morning, everyone. Thank you for joining us for today's training. Usually at this point, I would jump in and start a big spiel about how VIP is great. We want you all to volunteer for us and take our cases and why that's so important. But I just want to actually leave that up to our trainers today, especially Alfonso and Frank, because they have been wonderful volunteers for VIP. And Alfonso has also been a wonderful presenter for this type of training on multiple occasions. So I will leave that to them. And just as an introduction, my name is Denise. I am a supervising attorney with Philadelphia VIP, and collection and consumer debt cases is one of the case types that I supervise. With that said, Alfonso and Frank, please take it away.
Good morning. My name is Alfonso Madrid. I'm a senior staff attorney at Community Legal Services. I've actually been with CLS only about 3 years. Prior to that, I was a solo practitioner for about 10 years, and I focused my practice in consumer debts and home ownership issues, primarily a lot of Chapter 13 bankruptcy. As a solo attorney, I love taking these cases. They didn't take a lot of time, and they really do have an effect on people. I'll tell you just the thanks that the clients can give you for taking this relief off of them. And also advantages that sometimes the clients aren't aware of. I can't tell you how much times I have come across a homeowner facing foreclosure who couldn't get a loan modification because of a stupid credit card judgment that was against them a few years ago. So the work that you do in these type of cases is going to make a difference to them in the future, as well as immediate benefit.
Thank you, Alfonso. My name is Frank Trapani. I am, I guess, the only non-CLS lawyer on the panel. I have a two-person firm. Prior to starting my own firm, I was at Deckert, where I first began working for VIP on landlord-tenant cases. For the past 8 years, since I've had my own firm, I've done countless consumer debt cases. And I'm going to echo Alfonso's statements about just gratitude from the clients. I just actually tried a case a few weeks ago, and my client just called me last week to say hello, because I mean she's just the gratitude that they have, and also the need. I mean, without volunteers like us and you out there, hopefully, these clients will get steamrolled in municipal court. These debt buyers just go in, they just get their judgments, or if our clients do show up, they just get bullied into unfair terms. So I do think it's imperative, and I encourage everyone to volunteer. And I will even offer, if you go to my website, my phone number is there, my email's there. If you're reticent in any way, if you take on one of these cases, you can call me. I'll work on it with you. I'll go to court with you, just because once you do a couple of these, you realize that it's really not a huge time commitment. As a two-person law firm, we don't do any work like this. I'm mainly 100% in federal court. I work 7 days a week, and these cases do not take a lot of time. So hopefully we can provide you some guidance today. And like I said, you can take me up on my offer. If anyone has any questions, please feel free to reach out.
Thank you both. My name is Kerry Smith, and I'm a supervising attorney with Community Legal Services. And Denise, can you click the next slide? I'm going to kick us off today with just a brief overview of our agenda. We will be talking about first, I'll provide some context of what's going on in collection courts in Philadelphia and around the country. We'll cover initial considerations when you get assigned or agree to take on a case, the first steps you might take in evaluating strategies and approaches. We'll cover plaintiff's burden in the case, defendant's case, appeals from municipal court, and then post-judgment cases, petitions to open. About half the requests we get for legal help with debt collection cases at Community Legal Services involve clients who find out 5, 10, 15 years later that a judgment has been entered against them, and there's great need in this area. We'll discuss settlement and then also strategies and approaches in both municipal court and the court of common pleas, and discuss some resources. Next slide. So I just want to start by providing some context of regarding collection claims. So our courts in Philadelphia, like courts around the country, they've really been flooded with debt collection lawsuits. The Pew Charitable Trust just did a recent study on this issue nationwide, And they found from 1993 to 2013, the number of debt collection lawsuits had doubled nationwide, and they're eating up a larger portion of civil cases. So it's grown from 1 in 9 civil cases involve debt collection lawsuits to today, it's now 1 in 4 civil cases are debt collection lawsuits. So the volume's huge. Here in Philadelphia Municipal Court alone, there's 20,000 debt collection lawsuits filed every single year. And this rise in claims is really related to a dramatic growth in the debt buying industry. So these are companies that purchase old debts that the original creditor has determined to be uncollectible. We're not going to be able to collect this anymore. The debt buyers pay pennies on the dollar for these debts and then pursue the alleged debtors for the full amount. Often the debt buyers don't buy anything more than literally an Excel spreadsheet of an alleged debts. And many times those debt buyers do not or have any access or only limited access to the underlying documents. So you may be scratching your head and thinking, well, if they don't have any of these documents about the debt, why are they suing in a court of law where they would have to prove their collection cases in accordance with the rules of evidence? That doesn't seem like it would be a friendly forum for them. And the reason why they do is because their business model relies on default judgments and judgments by agreement. It does not actually rely on having to prove their debt. And so they flood our courts with claims. And all of that really means that in today's marketplace, there are often complete defenses to these collection actions. There's also been a lot of work to address this problem systemically. CLS and VIP, I think we're now in our second decade of advocating for reforms in the court to ensure that judgments against defendants don't get entered on insufficient claims. The CFPB, the Consumer Financial Protection Bureau, has taken enforcement action against the 2 largest debt buyers for suing without proper documentation of the debt, entering a consent judgment, and recently having to sue again to enforce that. And you can be a part of that solution as well by representing vulnerable defendants who are facing these lawsuits now, making sure that these junk debt buyers are held accountable, that they're put to their proofs, and that will help do 2 things. 1, prevent like the wholesale abuse of our court system, and 2, make sure that these vulnerable defendants, we're protecting the limited income that they have, the income that they need to pay their rent, to buy food and medicine, and not just be going into the hands of a debt collector who's engaging in wholesale abuse of the court process. And really, this is just not a matter of economic justice. It's also a matter of racial justice. There's been a number of reports that have showed, have demonstrated that there's a disproportionate impact on people of color, these cases. In fact, CLS commissioned a study from the Reinvestment Fund. They reviewed data from Philadelphia Municipal Court, and they found that Black Philadelphians are overrepresented among defendants in debt collection cases. So nearly half, 49% of cases involve Black defendants, while 41% of Philadelphia households identified as Black. And there were also racial disparities in the outcomes of these cases. But the Reinvestment Fund report found that representation improves outcomes for all defendants across the board, and it also has a mitigating effect for those observed racial disparities. So thanks for joining today, and I hope that provides some context of why these cases are so important. Next slide. These cases are filed both in Philadelphia Municipal Court and the Court of Common Pleas, and we'll cover both of those today. But I think the vast majority changes over time, but I think the vast majority of cases that we're seeing now are filed in Philadelphia Municipal Court. And I know for many volunteers with VIP, when they first start, municipal court feels kind of like the Wild West. It's in a court that people are not familiar with. So we're hoping that today we can kind of dispel some of the mystery about municipal court. This chart here is just a sort of a journey of how court cases, collection lawsuits go through municipal court. A statement of claim is filed. That's the way in which we refer to complaints in municipal court, a statement of claim. And virtually all of these filings go to courtroom 5. That is a judgeless courtroom.
Yes, courtroom.
Thank you. Yes, the air quotes are critical here, because again, there's no judge. And in fact, oftentimes there's no staff when you first walk in, and it's really a room that's run by plaintiff's counsel. And there's you as a volunteer lawyer, your job is to make sure the case, one, maybe never gets into courtroom 5. You never even have to step in there. We're going to talk a little bit about how you can make sure that doesn't happen, and actually get a trial on the merits. But here's what happens for the vast majority of these cases. They get assigned to courtroom 5. Again, it's a judgeless courtroom. It's run by a trial commissioner. 65% of cases served, and we'll get into that in an issue because there is a service problem happening in Philadelphia, but 65% of cases where there's service on the docket result in a default judgment for plaintiff. And those are on deficient claims. We'll take a look at a couple of the case examples where there's just really, despite the rules in municipal court requiring plaintiffs to prove damages in accordance with the rules of evidence before a default judgment can be entered, routinely these are just kind of churned out over and over and over again. That's 65% of cases. About 13% of cases result in a judgment by agreement. So what happens was when consumer debtors show up in courtroom 5, they have no idea what's happened. They think there's someone there for a trial. They think they're going to be able to tell their side of the story. And instead what happens, they get called into a side room. They're unrepresented, and plaintiff's counsel encourages them to enter into a payment arrangement on the debt. Typically, it's not a settlement arrangement that they meet. That's just a payment, like a settlement outside of court. Instead, they ask them to enter into a judgment by agreement. Usually, it's the full amount. And what that means is if the consumer defendant in the future is unable to keep up with those payments, the plaintiff already has a judgment that they can begin executing on. Some cases can get continued to a trial room. That's obviously extraordinarily difficult for an unrepresented defendant to even understand that they have the right to get out of that courtroom. And more often than not, what happens if they don't reach a deal, a judgment by agreement with the creditor there, is they come back to that judgeless courtroom. Our goal in these cases is to get out of courtroom 5 and get a hearing scheduled and a judgment on the merits. We'll go over that in a second. Next slide. This is sort of a screenshot of the municipal court docket e-filing system. It's a little less complicated, I think, than the Court of Common Pleas system. You do everything on this docket. You, as an attorney, you just simply register to become an e-filer. If you're just giving someone some basic advice who's a consumer defendant, they actually can register as well and be able to look at documents. This is how you enter your appearance. It's how you can file a petition to open, check out the hearing list, initiate continuances as well. Next slide. Courtroom 5 has gotten quite a bit of national attention and not good national attention, right? Human Rights Watch, which calls out human rights abuses internationally, has taken a look at what's happening in Courtroom 5. They did a report called Rubber Stamp Justice back in 2016. And focused on judges' courtrooms, and particularly highlighted Philadelphia as being a particular problem. And we have a quote here from the report, and I would encourage everyone to read it. Next slide. The author of the report spent a few days court watching in municipal court, and here you can see he tells the story of a conversation he overheard in Courtroom 5 with a debt buyer attorney, really pushing an elderly gentleman to enter into a judgment by agreement when the defendant really believed that he had some defenses. He couldn't understand how the debt had ballooned to that much, and had no idea how to actually get out of Courtroom 5 and have a trial and have their case be heard. Next slide. Representation, of course, makes the difference. And so here's how you can make sure your case doesn't get into Courtroom 5. We all have different approaches, so my colleagues on the line here might want to weigh in of how they approach this. Certainly pre-pandemic, typically what I would do is just show up in Courtroom 5, have a brief conversation with plaintiff's counsel, and get a trial date, get the case continued for a new hearing before a judge, so in Courtroom 2, 4, or 6. You technically, under the rules, have a right to a same-day trial. you can insist that the case be removed from courtroom 5 and go to before a judge. As a practical matter, for years, the court wouldn't recognize that right. But there's been a change in leadership, and Judge Wolf, the supervising judge for the Philadelphia Municipal Court, has said that people do have the right to a same-day trial, and he's working to make that happen. So you could insist on, showing up, having a trial that day. I would still advise you to bring a book. It might be a long process. You might be put on the end of some other courtroom's list.
So
there are
if
other
I
ways to
could
get a.
toss in my 2 cents.
Yes, thank you.
If you get this case 10 days before the hearing, upload a continuance request. It's a simple letter to the court saying, this has been scheduled for a first hearing in courtroom 5. Please schedule to a trial date certain. I can't guarantee this, but sometimes once they see that there's an attorney entering an appearance, I've seen these things get withdrawn. They just don't want to fight. Less and less so often, but it also gets you, you're going to get scheduled probably about a month out is usually what I see. And that way I never have to bother trekking down there. I've never found going to courtroom 5 particularly helpful in trying to negotiate anything. Usually the attorney there for the plaintiff is the warm body attorney. It's not the attorney who filed the case. And all he can say is, well, we'll talk to my client and let's do a continuance.
I have an approach on room 5 as well. I always typically go to room 5. Initially, the lawyers now know me, but initially the first question they ask is, how much can your client pay? And I always ask, where are these documents? I need these documents. Of course, they don't have everything I'm asking for. And then I explain to them that I'm a plaintiff's class action attorney and we'll cover, affirmative claims later. But these are some of the issues. My client has no money. Do you really want to waste your time here? Because if you continue to pursue this, you're likely to get sued. And on a couple of occasions, they either dismiss it outright, or to Alfonso's point, they'll never come back. So let's get a continuance, fine. They'll never come back. I have learned some lessons the hard way in room 5. I find that the judges many times are not very plaintiff friendly. And I did not send my notice to defend, but they were there. And I said, listen, I want to try the case. And they're like, okay, we'll get you before a judge. I waited there all day. I made my arguments as to why it's their case. Why should we have to send a notice to defend when it's their burden? And I lost that. So I don't make that argument anymore. But, to Kerry's point, it wasn't a very friendly forum for me. And I was frankly outraged that you can bring a case. It could be your burden. I can show up to defend it. And they just say, you know what, we're not ready. So we're going to have to just continue it. So that has happened to me.
Right. Lots of different approaches there. And thank you, Frank, for addressing the notice to defend. Provide some additional context, the rules in municipal court provide that if plaintiff chooses to send a notice to defend to a consumer defendant, the consumer defendant has an obligation then to put them on notice that they intend to show up at the trial and defend themselves. And if they do not return that notice, then the plaintiff has, under the rules, the opportunity to request a continuance. Not all plaintiffs comply with that rule. They do not send a notice to defend, or they send a deficient notice to defend. It's supposed to include an envelope, for example, to return. But that is something to be on the lookout for in these cases. Next slide, please. Cases also, we also do get quite a few cases that are filed in the Court of Common Pleas. I think probably most of you on this webinar today are more familiar with that process. And we'll get into more strategy discussions about this, but basically a complaint is filed. If no response is filed in response to the complaint, a default judgment can be entered after a 10-day notice of intention to file for default. Other options are filing preliminary objections to their complaint or answer a new matter. These cases, the vast majority of them are under $50,000, so they go to arbitration, and then there's a right to appeal any arbitration award de novo. We'll get more into that later on in the training. Next slide. We did put together we pulled a couple of examples, case materials. And Denise, did these go out to participants today? Or are we going to? You sent them this morning. Okay, great. I just wanted to, these are not community legal services clients. They're just two random cases that we picked up the docket to give you a little sense of the kind of cases that we're talking about. The Midland is the largest, they're the largest debt buyer plaintiff and represented in Philadelphia Municipal Court, filing the most claims. You can see their very bare bones complaint and exhibit. They did in their statement of claim indicate that they are the assignee of the debt. And they did actually list the original creditor, but you can see in the documents, they did not break down, as required by the rules, how much of the amount they're seeking is for principal and how much is for fees. And there's no documentation attached to the statement of claim. There's a simple verification by a staff person from Midland. There's no underlying documents. We also included a sample from Portfolio Recovery Associates, again, probably the second largest debt buyer appearing in municipal court. That actually has some documents, which you often you might hear the debt buyers, lawyers refer to it as media. But again, it's fairly bare bones. There's a bill of sale indicating that PRA has bought a set of bulk debts from the original creditor, but there's no real link to the consumer defendant. And it also references another agreement, a forward flow agreement, that is not attached. There is one purported statement attached to the PRA bill, but it starts with a balance of $4,000 and includes interest and fees, but there's no contract attached indicating that the consumer defendant has ever agreed to pay interest or fees. That you might be surprised, wow, that's pretty, there's not a lot of documentation even in the PRA statement of claim and exhibits. And I would have to say that's probably one of the most documented claims that I've seen by a junk debt buyer in Philadelphia Municipal Court. So it gives you a flavor of how little documentation they have, even in cases where they believe that they have the most documentation to support their claim. So that gives you a flavor of the kind of cases that you may be seeing. And we're now going to go on to initial considerations on how to approach these cases. And Alfonso is going to cover that.
Okay. So one of the things that I do when I first call a client is I ask them about other debts that they may have, that they may owe. I don't always get a credit report. Sometimes it is helpful, but sometimes, the client may have a fair idea of the debts that they owe. Sometimes they will have like their Credit Karma credit report. And I find that that's generally going to follow most of it as well as these. But getting an annual credit report is pretty easy. You can actually do it on the website with your client there. You do want the client there because there's usually some kind of security credit or security questions that you want the client, like their last job or which of these phone numbers you had, things like that. And that will give me an overall idea of their debt limits. Partly because I want to know, is this going to be the first of multiple lawsuits? And maybe they might want to be considered a referral for a bankruptcy. Next slide. Ask the client, what they want. Some clients are going to say that they feel like I owe this, that I want to pay it. I always say, well, let's look at your budget, because most of our clients, they're going to be mostly Social Security, retirement income, and I'll just kind of go over their expenses. I'll be like, well, what's your mortgage payment? What's your how much money you spending on groceries? If it's a family of 4, I know that they're spending at least $600 a month, and probably more so, this year with inflation. I'll ask them about their water bills or their gas bills. I'll be like, are you behind and maybe on a payment plan? Oh yeah, I'm under cap. That means that you're not even able to pay your regular water bill. Does it really make sense to try and pay this debt? And I'll explain to them that, the type of creditor that's coming after them. So this is a debt buyer, which, as Kerry told you, someone who paid pennies on the dollar for this claim. So, this is a $900 lawsuit. They probably paid, $10 for this particular debt. And do you think that it's fair that you pay them $900? And once they understand that, then they will, say, well, yeah, maybe I shouldn't just rush to do a settlement. I almost never settle these cases. I never promise my clients that they're if it's a debt buyer, I tell them, listen, I've been very successful with debt buyer cases. I think it's worthwhile going to trial, especially if it's a municipal court. And I cannot stress this, if this is a municipal court, this may sound a little sarcastic, It doesn't matter at all because you get to do it over again. So if you're worried about how you're going to look before a municipal court judge or embarrassing yourself, don't. I've embarrassed myself plenty of times in municipal court. Look at me, I'm still alive. I don't care if they yell at me. I've been yelled at by municipal court judges. You know, because no matter what happens, I can go in there, I can sing the national anthem. That's my case. Judgment against me, I get to do it over again. So you can't go wrong, basically. This is a municipal court lawsuit. I want to give you that assurance right there. Sometimes it is an original creditor, and that might be a little tougher case. And I'll explain that to my client is if, you know, yeah, they didn't attach their documents here, but chances are they may be able if they do that. Now, my own personal strategy on those is maybe they can prove it, but I can give them a lot of work to make them get to that. And sometimes I can tire them out, even if they are original creditors. That's something that I personally have my own personal approach to these. So I kind of give my client an idea of what I think what their chances are, what I think, you know, if they ask me, what do you think I can do, or what I'm willing to do, I'll say I'm willing to try it, and then we can go from there. Next slide. Okay, know your adversary. So as you start doing these cases, you're going to recognize attorneys, and you will actually start forming some connections with these people. Initially, when I take a case, I can send a letter to Pressler and Pressler in Jersey, you know, and ask them something. No one's going to call me back. But sometimes once I start working with these, I'll start having attorneys' emails that I know I can reach out to and say, hey, this is filed. So knowing who your plaintiff is and who their attorney is can be helpful. One of the bigger debt collectors, Kerry, I'm always getting his name wrong, Dimitri, what is last?
Saris, I think.
Saris. He and I have actually done enough of these that if I have a client who only has Social Security income, and depending on who his client is, like PRA or something, sometimes they'll just do like a hardship discharge. And I may just need to give them a copy of their award letter. So doing the more of these cases that you do, the more you'll be able to sort of do stuff at the beginning that you might not initially be able to do. Next slide. Know your forum, court of common pleas or municipal court. So as I said, the municipal court, I kind of take this with a long game, because even if I'm successful, I know the other side could appeal it de novo, and we're starting to see a little bit more of that. And so I really would encourage you all to consider the case with that strategy in mind, that you might be taking it to an appeal to common pleas. Common pleas, I always like, because I know that more likely than not, I may be able to get rid of the case on preliminary objections. And that can be a very successful strategy. Also, there is a bankruptcy option. Now, bankruptcy is very complicated, and I don't expect we're not here to give you a very complex lesson on the intricacies of bankruptcy, but we're going to do some overviews. If the client has a lot of debts, then maybe a bankruptcy may be an option, maybe something they may want to think of. I mean, if you look at their credit report and their total credit card debt is like $20,000, $30,000, then maybe it might be worth referring them, talking to VIP about doing a bankruptcy referral to Consumer Bankruptcy Assistance Project, or looking into that a little bit better under the analysis that we're going to go over. Next slide. Okay, so just to give you a quick overview of bankruptcy in general. So what most people think of when they think of bankruptcy is a Chapter 7 bankruptcy. That's a straight bankruptcy, or sometimes as I call it, a quick and dirty bankruptcy. It's very short, lasts about 4 months start to finish, and it wipes away or discharges the debtor's obligations to pay most debts. Some debts are not dischargeable in bankruptcy, like student loans or taxes, but most credit card debt almost always is. Now, Chapter 7 is what we call a liquidation bankruptcy, which in theory, the debtor's property could be sold by a Chapter 7 trustee to pay off their unsecured creditors. However, in reality, most Chapter 7 cases are what we call no asset cases, because you can either claim the exemptions that the bankruptcy laws give you, or their property is so encumbered by liens that there's nothing for unsecured creditors anyway. And it's only unsecured creditors like credit cards, medical bills, and things like that a Chapter 7 trustee is looking to pay, because that's how the trustee gets a commission. the trustee is selling assets, then the secured creditors just get paid as part of that asset being sold, and the trustee doesn't get anything out of it. So he's not going to go to that work for that. Next slide. The other type of bankruptcy that applies to most individuals is a Chapter 13 bankruptcy, which is more like a reorganization bankruptcy. Now, primarily, my clients do Chapter 13 because it's a way to address mortgage delinquencies if they can't get a loan modification or some other kind of relief. But Chapter 13 is available for some people, which are a lot likely to be our clients, to be quite honest. People who have some money, like in upper middle class or lower middle class, perhaps. They could afford to pay something, but they can't afford to pay all this debt. And in Chapter 13, they stay in it over a period of time, up to 5 years maximum, and pay something toward their unsecured debt, and then the rest is discharged. Chapter 13 can also be a potential option for a client who has some equity in their house that would preclude a Chapter 7, but that's really a little bit more complicated question, which you would probably want to refer them to a bankruptcy attorney for a consultation, or give me a call. Next slide. All right. So when we're looking at whether a bankruptcy is possible, again, the total amount of the debt. Bankruptcy is a very powerful tool. You don't want to use a bazooka to swat a fly. If this, if a $700 debt is the client's only debt, probably isn't worth the time and effort for a Chapter 7 bankruptcy. And also, you never know what the future is going to happen. Something catastrophic could happen in the future where they incur a ton of medical debt, and a Chapter 7 discharge wouldn't be available because they'd only have one in a year or prior year. There's no actual dollar limit. My rule of thumb that I used when I was in practice, private practice, was I would look at like $20,000, $30,000 is probably when they wanted to maybe think about that. Is your client collection proof? That's a big aspect for many of our clients. In Pennsylvania, we're one of only 2 states, Kerry, that you can't directly garnish wages for most judgment debts. Which is
one of the few. I don't know the number.
Yeah. However, money in a bank account can be garnished, but unless it's Social Security or retirement income, which is often the case for many of our clients. So if it's somebody who's only getting Social Security deposited in their bank account, even if they had a judgment against them, that creditor's not going to be able to freeze that account or take money from it. I think I've heard horror stories that sometimes banks have frozen accounts, even if it is, and it may take them some extra effort to undo that, but it's very unlikely. And unless they own real estate, judgment may not have much of a consequence. But if they do own their house, that judgment can be a lien on the property, or will be a lien on the property. And also, how resilient is the client? Sometimes when I explain to clients what their rights are, that they are collection proof, I'm like, do these phone calls really bother you, or can you just, see caller ID and ignore it? And if you can do that, these will decline over years. I mean, the time helps our clients in many of these cases. So I explained to them after about 4 years, usually you can have a statute of limitation defense, maybe even 3 years if it's a Delaware credit card. So these are all things that you should talk to your client about and determine whether bankruptcy is something they want to look into. Next slide. Now, remember we talked about Chapter 7, theoretically assets could be sold. I don't expect any of you to really do this, but I kind of just want to give you an example of something that I do when I'm looking at this. So for most people, people have stuff. A trustee in bankruptcy is not going to want to sell their household furnishings or their personal property because the costs associated with it would outweigh any benefit of values, unless they have a box of diamonds lying around. So most trustees are looking at big assets like money in the bank and the house or a vehicle. So for most of our clients, the big asset they might have is a house. And one thing I'm starting to see is gentrification in Philadelphia has increased the value of many of our clients' houses, which makes bankruptcy sometimes not an option for them because there's now a lot of equity. And if this asset, and if they have a very small mortgage or no mortgage at all, theoretically they could lose their house in a Chapter 7. So one thing I look at is the value of the property, and value can be a very hard thing to do. Easiest thing I do first is Google. I Google the property address. I'll look at the Zillow, Redfin, Realtor.com, kind of get an idea of what they're saying that, and remember that's based just on houses in the area. Then I might look at the house on Google Maps, a picture of the house. If it looks really run down, I might get an idea of is this house really, is the inside as bad? And I'll ask the client outright, like, does your house need a lot of repairs? That might mean that house is worth less. The city office of property assessment will also give you a value, in my opinion, that tends to be below what the actual fair market value is. So I do kind of look at a broad range of things. So here's an example. This homeowner has a house that's worth $140,000. We know that to sell a house, it's going to cost a minimum of 10% usually, because it'll be a realtor's commission and transfer taxes. And then there may be liens on the property that have to get paid off as part of the sale of the house. Here, there's a first mortgage, a second mortgage. Water liens, you can look on the Court of Common Pleas docket and see that there may be water liens or gas liens. PGW is owned by the city, so sometimes when someone falls behind in gases, then the city will put in a lien on that. Or prior judgments. If you look at the Corp CCP docket or municipal court docket, you may see prior credit card judgments for other debts. These are all now secured liens that would have to get paid if in the sale of a property. So in this case, there's $32,000 of equity. Now, in this case, the debtor is going to use his bankruptcy exemption. That's the dollar amount that is given by the bankruptcy code. And these dollar amounts are adjusted every few years for inflation. And here there's a potential $5,000 pool of money that could be available. So Chapter 7 might have a little risk here. In my experience, probably not. There's enough wiggle room here where I would look at the value of the property a little bit more closely. It might be worth the client's time to get an appraisal done, because an appraiser is going to look at the condition of the property and discount accordingly. An appraisal can cost money, however. Usually it's going to be about $300 to $400 for an appraiser. But if it's a close call, that may be something that a client may be willing to save up money to do that. And in fact, I'm defending a lawsuit against Discover for a client right now, so she can save up money to do an appraisal because she's kind of one of these close calls. Next slide. The Chapter 13 option, as I said, potentially, if they have the income, they could do a Chapter 13 to pay some of their debt and get the rest discharged. Or say, if you were in that prior example, they wanted to pay that $5,000 off in a Chapter 13 because of the equity problem, they could do that. It's usually not the best option for our clients because free representation is not an option for most of these cases. It's not something that's in our priority at CLS because usually our Chapter 13 cases are going to save the house. And the cost of a Chapter 13 bankruptcy these days are probably about $300 to $4,500, closer to $5,000 probably right now. There's a filing fee and there's a credit counseling expenses. Now, many private attorneys will put their fees into the bankruptcy as part of the bankruptcy payments, but they're usually going to want some amount of down payment. But also the Philadelphia Lawyer Referral Service, the Bar Association Referral Service, may have a list of attorneys that may charge less. But sometimes that is a way to address some unsecured creditors if the client is willing to pay something. And maybe something like I'll give you an example. I have a VIP case that I took with me to CLS for a client who was in a similar situation where there was some equity, and she's paying $82 a month for 5 years, after which the rest of her debts will be discharged. But that's a rare case. You're really not going to get attorneys who are willing to commit themselves to a 5-year bankruptcy in most cases on a pro bono basis. So next slide. All right.
I'm just going to interrupt really quickly just to talk about the VIP aspect of that. Overwhelmingly, VIP does not accept cases where clients are judgment proof. We talk about that with CLS a lot and PLA, unless there's compelling reason to do otherwise. We also try our very best to do a bankruptcy analysis before we pass our cases on to volunteers. But sometimes clients are always forthcoming with the information. They wait until they get an attorney to talk about all of these things. So if it does come up and you're concerned about it, we do not expect you in any way to take on their bankruptcy matter, but definitely let us know so that we can address it and possibly refer them to CBAP or another attorney to help them with that. Thank you, Alfonso.
Sure. And also, again, if you have a case and you just have a quick question or you want to run something by me in terms of a bankruptcy, feel free. My contact information is in the materials.
Okay. Thank you, Alfonso. I just want to, before I move on here, I want to echo some of the statements that both Alfonso and Kerry made. Kerry said earlier that the business model of these debt buyers is to essentially just get default judgments, and that's correct. So what everyone needs to remember is that these debt buyers don't want to do any work. So when it comes to the client intake and the issues that Alfonso addressed are not relevant only to bankruptcy. So when my client comes in, the first thing we talk about is, do you own a house? How much money can you pay? What are your assets? And how much money do you make a year? I ask these questions if obviously if there is a bankruptcy issue, we can go to Alfonso. But one of the issues, the leverage pieces that I use is when I meet with these attorneys, I say, listen, you're going to do a lot of work here. And maybe you win, maybe you lose. You're probably going to lose. And even if you do win, what are you going to win at the end of the day? You're going to win a judgment that you're never going to collect, because my client doesn't really have a lot of money, doesn't own a house. So those are issues that I think are going to be pertinent also to being able to defend these cases and to use that as one of the leverage points against these debt buyers. If my client does own a house, as Alfonso said, they get a judgment, they can attach a lien. They're usually concerned about that. So we talk about that, and we talk about likelihood of success in the merits and whether it does make sense to resolve these cases or fight through. And obviously the excellent point that Alfonso raised before, which is you have a de novo right of appeal. So no matter what happens in the municipal court, you get a brand new crack at the apple in the court of common pleas, which is a form that I prefer, because then we can really file preliminary objections, ask for discovery, and oftentimes, in my experience, they give up in that form. Like, okay, this is just not worth the time to collect this $2,000 judgment. So with that said, we'll move on to their theories of recovery here. And there's mainly two. I mean, one is the straight up breach of contract claim, and then they have what's called this account stated, which I don't really see anymore. So I want to focus primarily on the breach of contract claim. And the contract claim is pretty simple. Is the debtor entered into a contract either with usually with the original creditor, usually a credit card agreement, breached that contract, and as a result of that breach, they owe some sum of money. Next slide, please. So the contract claim is relatively straightforward in closed-end credit transactions. What that means is the balance doesn't change over time. You bought one item, it was for a set amount at a set interest rate. This is the amount owed. It is a bit more complicated in credit card transactions, where the salient issues that we need to be cognizant of are, number one, was there a contract between our client and the original creditor? Number two, does the debt buyer, do they have standing to pursue the claim? And oftentimes in these cases, what you'll see is some sort of transfer order or transfer document in the documents they provide to the municipal court, essentially saying, yes, we purchased the debt, Midland Funding purchased the debt from Capital One, and here's the acknowledgement, and then an Excel spreadsheet, as Kerry said, just listing essentially our client's name and the amount of the debt owed. So you have, do you have a contract, and does the debt buyer have the authority to pursue that claim? And that's something that we'll talk about in one of the ways that you'll challenge it. Number two is if they do have standing and there is a contract, what were the terms of the contract? Did our clients breach those terms, and what was the amount owed? Oftentimes what we'll see in these cases, and what I'll see, is you might have an unsigned boilerplate Capital One contract as part of the submission, and then you'll have a couple invoices. You won't have all the invoices. You'll have maybe one or two invoices showing a large amount owed. The invoices may show that my client maybe that month, billed $30, but they owe $3,000 because of the accrued interest over time. So the way we challenge this is you challenge every aspect of that. Next slide, please. And like I was saying, the contract claim is more complex in open-end transactions. They have to show both that there was a contract, and they have to show that the amount owed by our clients is the actual amount that they're entitled to, both with regard to principal and interest. I will tell you from personal experience, my clients typically, they don't know if that's the amount they owe. They don't even know. They just say, listen, I remember at some point in time, I took out a credit card, I bought a stove with it. That stove was, $300, and now they're saying I owe $7,000. So that's very, very important, is just because they've got an invoice doesn't necessarily mean that they can make out that damage claim, even if they can prove the contract that our client owes the amount that they state that they owe. So proof of the contract terms, Usually, like I said, they don't have a lot of documents. What they're going to have is a couple invoices. They may have a contract. If they do, I suspect it's unsigned and oftentimes doesn't even have our clients' names on it. So they're going to have difficulty linking that contract to our client and showing that our client assented to the terms in that contract. Obviously, we have here before, we have to show that the client assented to both the initial contract and any subsequent terms. Once our client stops using the service or the service is discontinued, they're not going to be able to prove assent to the contractual terms. Next slide, please. So in addition to the outright contract claim, Pennsylvania law does recognize implied contract. Here, in Discover Bank versus Stucco, we have a case where they didn't have a signed copy of the credit card application or the credit card agreement, but the unsigned copy of the credit card agreement asserted a course of conduct and established these acceptance. This is a lot of what you're going to see. In the last trial I had, I made the argument that there was no contract because the boilerplate unsigned contract was insufficient. And then they come back and say, well, we've got the contract and we've got the invoices and this establishes course of dealing. So what they're really signaling is his client's not here. We know they took out a debt, so we establish a claim. I would argue it's totally insufficient. It's still their burden. The plaintiff has the burden to establish both the contract and the existence of the terms. Next slide, please. Okay, as we're discussing, failure to prove the existence of the contract. Always deny. Like I said, I've never seen a case, and maybe Kerry and Alfonso have an example. I've never had a case, and I've done countless cases where they have actually produced the contract with my client's name and signature on it. It's always just a standard, creditor contract. I don't even know if they might even use the same one in all the cases.
Yeah, I have the same experience, and sometimes it appears that they have downloaded a template from the internet. So it actually has nothing to do with the account at issue. They just selected a generic Bank of America credit card agreement and attached it.
Right, and that's my experience as well. So, always challenge it and say, my client didn't agree to this, my client didn't sign to this. So there is no contract claim. So the contract claim fails as a matter of law just on that issue alone. And of course, they may pivot to alternative legal theories, but the defenses are essentially the same. The invoice, the proof of the invoice doesn't prove anything. And oftentimes when the amounts on the invoice, when they don't have any principal, when the principal purchase is $30, but they're seeking thousands of dollars, you would say, well, this doesn't prove anything. It doesn't prove that my client made the charges, and therefore the claim should be dismissed for failure to meet your burden, because you can't show that my client made the charges that you're saying that they made. And in fact, you don't even know what charges my client made. So that's how we attack both the direct contract claim and any implied contract claim. I mean, I would say that the issues are overlapping. Next slide. Right. So this is something that I haven't seen this in a while, actually. I don't really see the account stated claim, but just know of its existence. The account stated is essentially they rendered an account. So they'll use an invoice or something and they'll say, hey, listen, we let the client know that this was the account, this was the amount that was owed. And the gist of it is that the client assented to it or acknowledged that the amount that they're claiming is owed was actually owed. It's an alternative theory to the contract theory. And the defense here, again, is, well, this is not correct. Next slide. Right. So to prove the account stated, they have to show that the account was in writing and that it was rendered, and that the debtor actually agreed, accepted, or acquiesced in the correctness of the account. The acquiescence can be implied. If you look at the restatement, what it says is if a debtor has had the opportunity to scrutinize the account and didn't object to it, that can constitute acquiescence. Here, in these types of cases, these consumer cases, obviously, all they're doing is, we don't even know if they mailed the invoices to our clients. We'd say, listen, they have to show more than just the fact that our clients saw this. That there's got to be some measure of assent or agreement here. Next slide, please. I think the Pennsylvania courts are split on whether silence after receiving an account does constitute acceptance or does not constitute acceptance, as we have here. That's what they're going to argue. And what you're going to see, and what I see in municipal all the time, subliminally, what they argue is, Your Honor, this is a credit card debt. We know this person took out the credit card. And that's something you're just going to have to deal with. But that's my biggest hurdle is, whether that's right or not. I mean, we have rules for a reason, and it is their burden, as the slide suggests, and they just can't meet their burden by coming in here and say, hey, like, this is just common sense, just enter judgment, which is essentially what I always come across. And I always say that there's no way you can enter judgment in the amount that they're demanding, because they haven't established all the requisite elements, and they don't have the proof to do that. I had a case recently, my last case that I tried. I had an issue where I was in municipal court, and as Alfonso says, I get yelled at all the time, and it's not a friendly forum for me. I don't like being in municipal court. I don't practice there. I don't know the judges. They know these people because they're there every single day. And I had a situation where they had no witness, and they put on a case, and they submitted documents, and they said, here it is, Your Honor. Here's the debt. The client owes it. Just enter the judgment. And I argued, well, no, these documents are admissible. The judge says, I'm going to admit them anyway. We know, these are invoices. So what other argument do you have? So I was able to look through the packet and noticed, luckily, that there was no transfer. There was no transfer of the debt from the original debtor to the debt buyer. And I said, well, Your Honor, even if you accept these documents as true, they're not the real party in interest, as we mentioned earlier. They have no standing to pursue the claims. The claim should be dismissed, or judgment should be entered in favor of my client. And the judge actually agreed with me, because they actually were so sloppy. And I think had they had the proper document, I would have lost that case, but I ended up winning it. So just be very cognizant of those elements that they have to prove. It's all of it. It's the real party in interest. It's the contract. It's the damages, and it's the interest, which I'll discuss later in our affirmative claims and what some of the issues we could raise with regard to interest are. Next slide.
And it's worth noting with debt buyer cases as well in municipal court, they have a bill of sale. Bill of sale is not the contract that gives them standing. Those bills of sale specifically refer to a flow forward agreement or something, or sometimes will specifically subject to the terms and conditions of that. And I've successfully said, Your Honor, they're claiming to own this debt subject to this contract. This contract's nowhere to be seen. They never have that contract. And it's been pretty, it's been successful. Sometimes I once had a judge raise that himself. Judge Washington in municipal court. They had all they have were these statements. And say, well, Your Honor, these statements are admissible under Rule 121. It's business records. And he's like, well, yes, but it says these types of documents. It doesn't say anything about contracts. And you still have to show and you have the opportunity to sort of set the narrative in municipal court. I think a lot more easier than in common pleas court.
Right, and I echo that. I've never seen the underlying contracts as well. I don't know if this was stated earlier, but while it's on my head, I should mention it. I saw it in the slide somewhere, so it may come up. But you should always let the court know that you are a pro bono VIP. I find that that's helped me at times. I know I've mentioned it, and judges have knowing that you're there on a pro bono basis and devoting your time. I think goes a long way. But on the account stated, the recap, it is an independent cause of action. They have to prove, they still have to prove the account and the amounts that they're entitled to, and there will be no right to contract finance charges or fees assessed after the agreed upon statement of account. So it is an alternative theory. It is essentially they rendered a set amount owed, and that there was some sort of acquiescence by the client. Next slide.
I know we're going to reserve some time at the end for questions, but we did have a question in the chat. It says, do they need to provide the redacted spreadsheet of accounts?
They do often provide it. They need to provide, well, I would argue they need to provide everything to show that they owe the debt. So yes, they would have to show exactly the contract between debt buyer and original creditor, and all the original documents, the original credit card agreements, and the invoices, and all documents showing that our client actually owes the amount that is stated on that spreadsheet. And Alfonso and Kerry, if you have anything to add.
I just wanted to, I was just going to mention Will in the chat was giving a good tip to really kind of, if the plaintiff does purport to have the contract terms. To really take a close look at that, Will was pointing out sometimes the fine print at the bottom of the sample agreements proves that it was not actually the contract that could have been an issue, because maybe the dates are different. I've certainly seen, where they have billing statements that show late fees that don't match the contract agreement. And so it's clear, if you can point out inconsistencies, you can show the court that there's something shady going on, that these are not business records that are trustworthy and that they can rely on for validity.
And I would just add that those spreadsheets are not very easy to read. I mean, they really don't show anything. You'll see just a bunch of black lines, your client's name and an account number. And sometimes that account number may not match the sample statement that they have. Because for whatever reason, mortgage, these credit card companies will change the account number. Maybe it was a lost card or something, but I sometimes see discrepancies there. So if anything, those spreadsheets may even make their ownership of the debt more muddied.
Carrie, I think we're up on
Yep.
defendant's
Great.
case. You wanna?
Yeah, I'm just gonna kick us off, and then Frank will carry it through. But just to highlight some common defenses that we raise in the collection lawsuits. So as I think the theme is clear here. A big part of these cases is holding plaintiff to its burden of proof. But there are clear defenses you can raise as well. Some of the less common are identity theft. Usually those can be resolved pretty quickly and maybe even pre-lawsuit filing. Mistaken identity. I had a client who had a very similar name to mine, Kerry Smith, not exactly a unique name. And it just came up in a petition to open context where her bank account had been garnished. And once we actually went through and looked at the documents, the wrong individual, like the wrong Kerry Smith, had been sued. And that resulted in a bank account garnishment. We were able to resolve that quickly, but that issue comes up. So these are some of the common defenses. And I'm going to just quickly run through the two most common. One that we've already begun to touch on, which is that the plaintiff doesn't have standing, right? This is really part of their claim. If they're a stranger to the contract, they have to show that they have the burden, but we sometimes frame this as a defense as well. And then cover statute of limitations issues. Next slide. So in Pennsylvania, lawsuits have to be filed by the real party in interest. And there's a great Pennsylvania Superior Court case, Atlantic Credit, that is exactly about a debt buyer case where the debt buyer did not actually prove that it had standing to bring the claim. And we cite that regularly. Next slide, please. When I present the defense that the plaintiff has not met its burden of showing that it has, that it's the real party in interest, that there's a standing defense, I always try to put these issues in context for the court. So explain why are we requiring them to prove that they're the actual holder of the debt? Because we want to make sure that this individual is not going to be subject to multiple liability. If a judgment is entered today that junk debt buyer A is the owner of the debt, but then they get pursued by junk debt buyer B later, that's an issue. And so it's a really important exercise for the court to ensure that the person who's suing is the right party. It's the party that actually owns the debt. And doing that exercise in the context of the debt buying industry is particularly important. Next slide, please. This is an industry that, if you haven't ever read this book, Bad Paper by Jake Halpern, I recommend it. It's his experience with junk debt buyers who go around buying these debts. It kind of reads like a John Grisham novel. It's kind of the seedy underworld of junk debt buyers. But I try to put this, I'm sorry, let me go back a slide. We're in the statute of limitations. Sorry about that. I try to put this issue in the context for Judge that there is a huge problem in the debt buyer industry of junk debt buyers selling debts that they don't actually own, or selling the same debt to more than one other junk debt buyer. I often will bring with me, even municipal court, like a 1-page or 2-page trial memo. I'm happy to share it with anyone that has a long string cite of debt buyers suing each other, saying, hey, you sold me this debt and you didn't actually own it, or you sold the same debt to more than one person. And I think providing that kind of context in the court helps, give the judge a real reason to look with critical scrutiny at the documents the debt buyer is using to try to prove their claim. Okay, next slide. Statute of limitations is a defense as well. I mean, this was a bigger issue, I think, like 3, 4, 5 years ago. I was seeing more of these cases. I'm seeing less frequently now, but I think it's important to run through. Generally, there's a 4-year statute of limitations for contract claims. There is an exception for contracts that are signed under seal. That rarely comes up in most of these cases. The only exception I would say is private student loan collection. Sometimes private student loan contracts are purportedly signed under seal. And basically what that just means is the word seal, S-E-A-L, is right next to the signature on the contract. But the case law is clear that it's more than just having the word seal next to the signature. It's the intent of the parties that it's at issue. And so I always raise that issue that there's every client I've talked to where there's a private student loan contract that's purportedly signed under seal has no idea what that means. They had no intention of signing a contract under seal. And so I typically raise a statute of limitations as defense because those are often filed more than 4 years beyond the alleged breach. Next slide, please. These are just a slide and some tips on how to determine the date of the default. Most, I wouldn't rely on the junk debt buyer's records for sure. Our clients don't necessarily know when they stop paying either. Sometimes you can kind of infer it from information like the charge-off date from the original creditor typically is 180 days, 6 months after the first missed payment. So these are some ways you can try to figure out when the last payment was made. Next slide. One important thing to know is that consumers sometimes can restart the statute of limitations period for contract actions. And I often like to talk to clients about this if we're wrapping up a case. So maybe I was able to get a case discontinued based on somebody's financial hardship. And I want to advise them, you probably are not going to be sued again. But if you are, you need to be careful. If someone tries to collect this debt again, you don't want to acknowledge the debt. And one of the most common ways you can acknowledge the debt is by making even a small payment on the debt that can restart the statute of limitations. So it's always a good idea when wrapping up these cases to walk, if you haven't gotten the case withdrawn with prejudice or a trial decision in your favor. If for some reason the case is just withdrawn, you want to make sure you're advising clients not to restart a statute of limitations on that debt. Next slide. We're going to talk a little bit more about affirmative claims, but I just wanted to highlight that suing a consumer defendant when the statute of limitations for suing on that debt has expired gives rise to a claim under federal debt collection laws. So there's actually, not only is it a defense, but it also raises an affirmative claim. Next slide. And I also just wanted to highlight an issue. I think this comes up more frequently. Is what state law applies to the statute of limitations. So we've got a 4-year statute of limitations for contract actions in Pennsylvania, but some credit card agreements have a Delaware choice of law provision in the contract agreements. Or I handled a case recently who had a New Hampshire choice of law. And both Delaware and New Hampshire have a 3-year statute of limitations for contract claims. Pennsylvania, its borrowing statute, we apply in Pennsylvania the state law that has the shorter statute of limitations. So sometimes it's really worth drilling down, and even if they've downloaded a template of a Bank of America contract that you think is bogus, if it has a Delaware choice of law or New Hampshire choice of law or some other state with a shorter statute of limitations, it's worth exploring that and whether that can be used to defend the action. And I think that's it. Next slide. Yeah, and Frank's going to take it from here.
Sure, thank you, Kerry. And looking for affirmative claims, Kerry mentioned it. Our firm did actually successfully, we filed the class action against the debt buyer for filing a time bar debt. It was something that happened a few years ago. I know there's good case law on this, and filing a debt that you know is time barred violates the FDCPA. So definitely keep that in mind. That's just one of the potential affirmative claims. One of the things I do when my client comes in addition to what Alfonso discussed earlier and going through the finances, is I ask them to bring in every document they have regarding the debt, every single communication from the creditor, every letter, simply because I want to go through it to see if I can find a violation of the FDCPA or the UTPCPL. And there is a provision of the Consumer Protection Law of Pennsylvania that essentially incorporates FDCPA violations. So if you have an FDCPA violation, you also have a violation of the Pennsylvania Consumer Protection Law, which many of you may know carries with it attorney's fees and treble damages. So it is a pretty plaintiff-friendly statute. What you're looking for in these cases, obviously, you have any type of abusive conduct, calls after 9 p.m. or before 8 a.m., contacting others to buy a debt, demanding payment in excess of what the debt is owed. Those are kind of what you see in the websites. There's two additional avenues that I look to that I've had success with in terms of telling the debt buyer that if you pursue this, you might be challenged on this point. One, I always look to, they have to send a notice to the debtor telling them the amount of the debt, what's owed, and the debtor has an opportunity to dispute the debt. So I look to see if there's any indication at all in the correspondence between my client and the creditor to see if they've actually disputed the debt. If they have disputed the debt, the creditor has an obligation to what's called validate the debt. There's no time within which they can do that, but they do have to come back and show that they've done their due diligence and provide additional documentation to show that the debt is valid. If they file a suit before they've done that, then they violated the FDCPA. That's one avenue I look to. Another one is the interest rate that they're seeking to collect usurious? And what I mean by that is it typically would be under Pennsylvania law most times. However, the National Banking Act provides banks with special rules. So essentially, if you're a bank in another state, you can apply that state's interest if you're seeking to collect a debt in Pennsylvania. I think there's case law on this when I looked at it years ago, and I say, well, you are not a bank. You are a debt buyer. Therefore, you do not have the ability to collect the interest that was being charged by the original creditor, who was a bank in the situation. And if you continue to pursue this, you will be sued. And there was a split of authority on this issue. Arguments on both, like, I think if they're continue to charge the rate after they purchase the debt, I think that would certainly be usurious. The arguments that I've seen both sides make on the other side is, well, no, the bank was entitled to charge that rate, and we just purchased the asset, which includes the debt that they weren't entitled to charge. Okay, maybe that's right, maybe that's wrong, but there is a potential violation there. So you look for debt validation. I look for debt validation. I look to see whether they can charge the interest rates. I look to see whether the claim is time barred. And as Kerry said, I tell my clients, please do not acknowledge the debt in any way, and do not make any payments on the debt, because that will reset the statute of limitations. And I look for any other abusive, what potential violations of either the UTPCPL or the FDCPA. And to me, litigation, both whether I do it for VIP or my other clients, is all about leverage. And this is just one of the leverage pieces that our clients have that we can press upon against these debt buyers. So next slide. I think that's the only slide on this. Oh, there we go. So debt buyers are subject to the FDCPA. I mean, there's no question about that. I've sued debt buyers for violating the FDCPA. So just keep those issues in mind. Can you go to the next slide, Denise? Okay, and the business records. So there is no doctrine of a corporation in Pennsylvania. Essentially, what that means is that these debt buyers can't simply rely on the business records of the predecessors. They have to independently authenticate the documents, show they're reliable in order to get them admitted. Commonwealth Financial Systems versus Smith, which is cited herein. If you're going to take these cases, that's a case you should be familiar with. It's a case I bring with me to municipal court and common pleas anytime I handle one of these cases. It was a great case where the Pennsylvania Superior Court essentially threw out a case where debt buyer tried to come in and authenticate records, both an unsigned credit card agreement, invoices, and various other documents. And the testimony in the trial court revealed that the debt buyer really wasn't familiar at all with the original creditor's record keeping systems, had never spoken to the original creditor, had no knowledge at all about the original creditor's records, and essentially, due to failure to authenticate the documents, the debt buyer had no evidence, and the case was essentially thrown out. Which is essentially what I argue when I bring these cases. I bring that case and I say, hey, listen, they're never going to bring a witness from the original creditor, and if they ever do bring a witness, which just happened to me maybe once or twice in the last 10 years in these types of cases, they simply don't have the requisite knowledge to authenticate these records. This is an issue that you're likely never going to see in municipal court. You may see it in the court of common pleas if the debt buyer is really zealous and wants to pursue the claim. So just be very, very cognizant that you challenge the business records. Most times they will not be able to authenticate these records, and most times they're going to be deficient for the other reasons we mentioned earlier, is that there's just simply not going to be enough of them anyway. Next slide, please. Business records in a municipal court. This is a very, very important distinction, and one that I learned on the fly, not being familiar with this rule. I got up in front of the judge. I said, Judge, I don't have a witness. I need to throw the case out. And lawyer for the debt buyer said, aha, I got you, Rule 121. And I said, oh, what's Rule 121? The judge said, well, actually, Rule 21 says that if they provide your client with notice, 10 days written notice of intention to offer the exhibits, that they can use them. So just be cognizant that in my experience, the judges will accept this if the other side has provided the 10-day written notice. I will note that in my case, I was a second VIP volunteer to handle the case. There was nothing in the file suggesting that they'd given us the materials prior to the hearing. I certainly had been entered for 2 months, and I raised that to the judge. I said, listen, Rule 121, even if it says what it says, and it's new to me, they haven't provided the notice. My client has counsel, and the lawyer for the buyer said, no, we sent it to her house in February. This was like 8 months earlier, and the judge accepted that. Luckily, we got the case thrown out for the reasons I mentioned earlier, that there was just not enough documentation in there. But just be cognizant that municipal court is a little bit unlike CCP in that there is this escape hatch here where ultimately, any documents which appear to be made in the regular course of business do come in. And Alfonso, you had mentioned earlier on the contract. Have you successfully argued that the contract doesn't satisfy the rule?
Well, Judge Washington raised that himself. I'll be honest, I was arguing some other stuff. I missed that. He was like, well, yeah, but if we look at Rule 21, it's a bill, estimate, receipt, statement of account, or other records that appear to have been made. What about the contract? I think you still have the burden of authenticating a contract that shows your ownership of this debt.
I think
So I think that that's a decent argument to raise. Don't feel bad if it's rejected. I mean, a lot of municipal judges are going to kind of look at the rule, partly because I think they know you have an appeal de novo. So a lot of this, it doesn't necessarily mean that you're wrong. It's just maybe which judge you pull. And that's just kind of the way that is.
That's my experience as well. I think a lot of it is judge specific, and I hadn't thought of the issue that Judge Washington raised. Obviously, an excellent point that I will raise next time, that we should raise in terms of whether the contract qualifies or not. Next slide, Denise.
There's a question. Do they have to provide proof of the mailing? I don't think so. I think the mailbox rule, as long as they certify that they put it in their mail, that they probably would. That's probably going to be sufficient.
Yeah, I raised that. So just keep in mind that in my case, this was in the hearing in September. The lawyer claimed that he had mailed these documents to our client in February. Now, our client had been represented essentially the whole time. I don't think that he was telling the truth, but the judge did accept it. And I asked for proof, and he said, I'm a lawyer. I'm telling you this happened, and the judge accepted it. So just keep that in mind.
And on the other side, sometimes it has worked in cases that while the firm that filed it sent me the documents, the attorney that showed up, who's not even associated with that firm, but it's the court person, didn't have them. And I was not my burden to tell him that I'd received anything. So he only relied on what was on the docket.
Right. And I should note that the judge did draw the line. In my case, there were missing documents, and the lawyer that said, oh, no, we did include those too. And thankfully, the judge says, well, no, I'm not going to go that far. You've handed up what you submitted, and this is what I'm going to accept. So just make the arguments, make the best arguments you could make. And as Alfonso says, a lot of times this is judge specific, and you have your de novo review. It's just, we do the best we can, and hopefully, we prevail.
Yeah. There's okay. I was
No,
gonna
go ahead.
say, there's a couple more questions, I think.
Sure.
One question is a client required to appear in municipal court, or can the attorney appear alone on client's behalf?
Okay.
And I'm interested.
Alone, attorney
Alone.
we were gonna cover this.
That's our story, and we're sticking to it.
Yeah, it depends. If I have a client who says, listen, this isn't my credit card, I never took out the debt, and that's what they're going to testify, I would bring them. If I have a client who oftentimes I do, who says, listen, my mom got sick, I just, I didn't make the pay, I did take out the card, I didn't make the payments, I never bring them, and there's no obligation to bring them. And I don't bring them because obviously then they do have a witness, essentially our client, who they can use to prove their case.
It is worth noting, they can give notice though.
Right.
Correct.
They can
Never
subpoena
happened.
somebody. Right.
Yeah.
And I've certainly, I think that she's no longer there, but there was one judge in municipal court who would lecture me and from the bench tell me, you better not have instructed your client not to appear here today. And I would just listen and listen and listen. And then she would go on and on and on. And eventually she still found in favor of defendant and we would win those cases. She didn't think she's no longer on the bench. But, sometimes judges give you a hard time about it. But just I had to point out, like, she's not a necessary witness for the defense. This lawsuit was brought by the plaintiff, and plaintiff doesn't have a witness here today.
That's exactly right.
Yeah.
That's why you love
I've never had a judge enter a default from failure to bring a client. But not that I disbelieve that that's happened, but it seems like you have an excellent appeal point there.
Yep. I think we've covered Rule 21. I think we're running short on time. I mean, we can go to the next slide, and if there are other questions, however you all want to handle it. Oh, the business records and CCP arbitration. Also, I don't know how many of you have participated in the arbitration program, but if the amounts in controversy are less than 50,000, you end up in the R program. Similar issue, but they do have to, the documents had to have been authenticated at some point. So, the arguments are the same. We bang the drum that they just simply cannot authenticate these documents, because if they are a debt buyer, if it's the original creditor, then if you bring a witness, then they will be able to likely authenticate the documents.
Sorry
Right.
about that. Got a little
No
happy.
worries.
You can go to the next slide. So, in retrospect, no matter what form you're in, whether it's municipal court, arbitration, CCP or CCP, you object, and you object on every ground you can think of. The records weren't contemporaneously made, they're not kept in the ordinary course. There's not a regular practice of maintaining the record. The person who's testifying doesn't have any sufficient knowledge to authenticate the documents. The documents lack trustworthiness. I think one of the commenters earlier or had a question about the contract. Sure, you look at the contract to see if you could bolster that argument, and then any other grounds you can think of. But essentially, Kerry mentioned it earlier. It's not our burden. We don't have to do anything. We don't have to bring a witness. We can just sit there, and it's their burden to show that they have the evidence to establish all elements of the claim. That's it. Yeah.
All right, just a quick thing on municipal court appeals. Remember, the right of de novo goes both ways, which means that you might be very successful in your case and gotten a judgment in your client's favor, but the creditor is going to appeal. So we do ask that you please consider taking it to the appeal. It's really not that difficult, and there are lots of traps for the overworked debt collector attorneys. It's not that difficult to file a note. You file a notice of appeal in Court of Common Pleas with a rule to file a complaint. And the case management order is generated, and you serve those on the creditor, on the plaintiff in the municipal court. And the attorney is going to get an e-notice anyway, because when you do the appeal and reference the municipal court number when you're filing it, it automatically appears on the municipal court docket as well. But you do need service. And then if you're the one, if you're the client, the party appealing, so let's say you lose and you appeal, then you initiate the notice, you give them a rule to file a complaint, and that complaint has to be filed within 20 days of the notice of appeal. It's not that uncommon for them to miss that deadline. After which then you can file a non-pros. Now, the other side, if they appeal, they still have to file the complaint, and if they don't, then you can simply file a press appeal to strike the appeal. Remember, these creditor firms are filing tons of stuff, and they oftentimes miss those deadlines, and that may be the end of it. The creditor can file a motion to reinstate, and sometimes they do, but the more time that passes, the harder it is for them to meet that burden of doing that. And so when you get to appeals, the complaint is almost always going to be subject to preliminary objections, and probably a second round of preliminary objections, and maybe even a third round. At which point you may get that thing stricken for permanent, because the judge is going to get tired of you having to bring these preliminary objections. So a lot of what we've given you in terms of the trial strategy and stuff is going to apply, I think, mostly in municipal court. Very rarely do you get all the way to an arbitration. I probably haven't been to an arbitration in 20 years. So, but it will happen. So please consider taking these appeals. It's not that much more work, and at that point, it's really just a matter of motion practice, which is kind of fun. Next slide. And I think that's it. Then we'll go on to post-judgment cases now, which, as Kerry said, we get a lot of people who don't discover this. They've been sued until after the judgment's been entered and their accounts have been frozen.
Right. Hello, everyone. I'm Lelabari Giwa. I'm a new attorney at CLS in the Consumer Rights Unit, and I'll cover this section. So as Alfonso said, many of our clients don't find out about their hearing, and a lot of these cases result in a default hearing where judgment is entered by default for the plaintiff. And this happens for a number of reasons. One is that, as you can see, 95% of defendants don't have representation, and 65% of those lose by default. As Kerry noted earlier, there are a lot of service defects. Oftentimes the affidavit of service, they'll say that they left the paperwork and statement of claims for adult in charge of the residence, but there's no ID to verify that that adult is actually in charge of the residence or the person they say. Oftentimes when we're going over the affidavit of service with clients, they'll say that the description doesn't match them or anyone who lives at the household, or sometimes there's the wrong address. And the courts don't really review these affidavits of service. And so if there's any issues, it's really on the client, or if they're represented, the attorney, to bring up that there's an issue of service. They never got notice of this hearing. Even if they did receive notice of this hearing, there's other challenges. Many folks can't take time off work. It's difficult to navigate getting to court, especially if they're an older client and have mobility issues. Many can't coordinate childcare and don't want to bring their children to court, especially during COVID times. A lot of our clients are extremely fearful of coming to court without representation. Many have a misconception that they might be facing jail time or might get arrested. And there's a lot of shame associated with having these debt collection lawsuits that can prevent someone from coming to a hearing, even if they get notice. Also, the statement of claims doesn't really have that much clear directions. You said you are noticed to appear at this hearing, you get the date and time, but there's no information on who's going to be there, what's going to happen, what someone should do. It's really confusing and really intimidating for many clients. And so that's part of the reasons why many of these cases end up in a default judgment for the plaintiff. Next slide. Oftentimes we find that clients don't understand or get any knowledge that there's a judgment against them until many years after there's been a judgment. So one can be if their bank account is garnished and they try to take money out of their account, or they get some sort of notification from their bank that there's an issue, and that might be the first time that they hear that there's has been a debt collection lawsuit against them. And even then they might not have full access to all the paperwork. As Alfonso mentioned earlier, some people first find out about judgment against them when they're seeking a loan modification and find out that there's this old credit card case and now there's a lien on their home that they didn't realize was there. Some bankruptcy attorneys look through the docket to see who has judgments against them, and they'll contact our clients saying, hey, you have this judgment against you for this amount of money. You don't have any options. Hire me so that I can represent you in a bankruptcy, which is obviously very distressing for folks and really concerning for that to be the first one. Theoretically, folks are supposed to get a notice of the judgment mailed to them, but oftentimes that doesn't happen. Some of that stems from the service defects that we mentioned before, and some of it stems from just issues with the Postal Service and delays or people not opening up mail that they don't recognize. Next slide, please. So one of the options when you're working with a post-judgment case is to file a petition to open the default judgment against your client. There are 3 factors that you need to prove in a petition to open. The first is that there's a reasonable explanation or excuse for not appearing at that hearing. Often when we're working for clients, we'll kind of drill down on the service issue because that can offer a reasonable explanation why you didn't appear at the hearing. Sometimes also if you're talking about like if you weren't able to take off of work or different things like that, you can put that in there, but service is often a reasonable explanation for that. Or if you didn't understand that there was a hearing to begin with. The second factor is that after you learned about the judgment, that you promptly filed a petition and made steps to protect your interests. And it's really important that this is from the date you discovered that there's a judgment against you, not just that there's a debt collection lawsuit. And so many people might know that there's a debt collection lawsuit, but not necessarily understand that there was a hearing and a judgment has been entered against them. And it's from that point that you kind of quantify whether or not this petition was promptly filed. And the third is whether you state, and you don't need to prove, that there are meritorious defenses to this debt. So this could be, this is identity theft. I never opened this account. I don't know anything about this account. It could be with a debt buyer. I don't owe money to this party. They're not the real party in interest. It could be a dispute of the amount that is owed, saying, I don't actually owe this party this amount of interest. And again, you just need to state these offenses. You don't have to prove them at this point. And there is an overall equity analysis to seeing if, there is any injustice that happened at the initial hearing that the court takes into account. Next slide, please. So to submit a petition to open, one thing that you can do, and we'll talk more about using petition to open as a negotiating tool a little bit later, is consider reaching out to plaintiff's attorney and seeing if they'll voluntarily open it. That also might open up room for further negotiations on that. If they don't agree or you decide not to do that, you file through the claim system. There was a screenshot earlier of the claim system that Kerry went through. You click initiate new petition, file a petition to open. You have to map to the party that you're representing, and then you're going to be asked to fill out 2 prompts in paragraph form. You might notice that the petition to open, you're supposed to prove 3 factors, but they only ask you 2 questions. This is something that's extremely confusing to clients who are representing themselves pro se. So the first one is explaining the failure to appear. That's that first factor. And the second prompt is petitioner has a good reason to proceed in that. And that's usually where we put the next 2 factors, the one about promptly filing the petition after knowledge of the judgment, and also stating meritorious defenses. At this point, when you file, there's no service required. you can just email plaintiff's counsel. The court will either grant a hearing for a petition to open or deny without a hearing. If it's granted, you'll usually get an email saying that your petition has been granted, and to call the court to schedule a hearing. It usually scheduled within a month. You have to do that within 5 days. And that's how that situation works. Next slide, please. So at the petition to open hearing, your client does need to be there to testify. So unlike the hearings that we were talking about earlier, which is just a general debt collection lawsuit, your client does need to be there. It's a separate hearing from a hearing on the merits. And it's really important that you keep track of where you are. For example, you just need to state your defenses. You don't need to prove them at that point. And there's also different standards of review. The judge will make the decision after both sides make their arguments and questioning of the witness if necessary. That doesn't always happen. Sometimes as an attorney, you can just kind of make your argument and they don't necessarily have questions for their client. Sometimes they do. If granted, then they'll say something like, are you ready to proceed to trial immediately? In practice, this rarely happens where they immediately go to the trial on the merits, but it is a possibility. It does happen. Some pros and cons to consider when you're deciding whether you want to proceed to trial immediately. A con is that your client is there to be a witness for the plaintiff. And so again, if it's, a situation where a client says, I did have this account, there were some issues that came up and I stopped paying, you don't want them to be there to testify to that on the record. Another is, if it's a busy court day, is a judge in the mood to have another trial? They're in the mood to be friendly to you as a defendant's counsel. That's something you need to consider. But in a pro, it gives less time for the plaintiff's counsel to prepare, and they can't send more documents if there's deficiencies, and they can't be as responsive to the meritorious defenses that you stated in the petition to open. So that's something to consider and kind of think through and talk through with your client about whether you want to proceed immediately to a trial on the merits. If denied, again, you get a redo in the court in common pleas. And it's really important in the petition to open in that if there's an active garnishment on your client's account, that you ask the judge to immediately release the funds so there isn't delay in them being able to access funds that might be really necessary to meet their basic needs. Next slide, please. And if your petition to open is denied, you can appeal to a court of common pleas. You'll first start by filing a one-page notice of appeal within 30 days. Of that denial. And then 20 days after that, you need to file a notice of appeal with a motion and a memorandum of law. You want to attach your statement of claims and any relevant case documents and also a stenographic record. This is like a motion. It's decided on the papers. There won't be a hearing. And if granted, the case will go back to municipal court for a trial on the merits. Next slide. So it's important when you're kind of going through what you're going to put in your motion and memorandum of law to treat any element in the municipal court order that isn't cited as a grounds for denial as an element met. So if any of the 3 factors aren't cited, then you can say, we've met this and focus on that other factor. Again, the defenses in municipal court that they say aren't meritorious can sometimes be met when you get to court of common pleas. Oftentimes, this is a good space to talk about standing with debt buyers. Did they really show a clear, straight line of assignments? Have they shown that there's the bill of sale and also the forward flow agreements, and also that the specific account was actually related to the batch sale of accounts that they're talking about? This is a good space to do that. There's also something that we see less often now, but that we did see in the past in denials of petition to opens in municipal court, and that's due to presumption that clients get notice that there's a judgment against them when the notice of judgment is mailed and received. And that goes to the second factor in the petition to open. You'll go to the next slide. So the presumption, and we argue this is a double presumption, which isn't probable, is that first, that when there's a notice of judgment, which is auto-generated, that it is mailed to clients, which doesn't always happen. And then the second presumption is that they actually receive it. And we argue that's not how the mailbox rule. This is actually a double presumption. And so we see this less now, but that's if you see that in your petition to open, that it was denied around the second factor because they assume that your client had more notice of a judgment against them than they actually did. This is an argument that we make. Next slide, please. Again, you can use a petition to open as a really effective negotiating tool. Many of these attorneys are only used to dealing in default judgments or judgment by agreements, where they kind of coerce clients who are really scared and unrepped to enter into payment plans, and they really don't want to litigate this case, especially debt buyers, where they only pay pennies on the amount that they're seeking. If you file a petition to open, they may agree to vacate or settle in exchange for agreeing. It could be a way to reduce the amount that your client owes, even if there has been a judgment against them. So these are really important tools and ones that should be considered when you're working with a client that's post-judgment. Okay, I think this is Kerry.
Yeah, so that's all an explanation of what to do with petitions to open in Philadelphia Municipal Court. It's a little bit of a different process in the Court of Common Pleas. Just be aware, it's all pleadings. It's not a simple, two-page, two-question form. You actually have to file a motion and attach to it your proposed answer or proposed preliminary objections that you will file if the petition to open is granted. However, some good news, the first two elements of the petition to open under the rules of Court of Common Pleas, those are met if you are filing the petition to open within 10 days of the default judgment being entered, and you just then have to focus your pleading and memorandum of law on the meritorious defenses. Just one cautionary note, if there's a basis to strike the judgment, you should include that in your petition, as well as all issues need to be raised simultaneously. So it's a little bit different in the Court of Common Pleas, a little bit more complicated. But again, as Lelabari mentioned, these are really critical cases to take, and we encourage you to take petition to open cases. That half of our requests for legal services are from people who are facing default judgments they never knew about until their bank account was garnished years later. So this can provide them with some really important relief. Okay, this is me, sorry. I'm gonna just run through these quickly. Settlement, we expect, sometimes these cases we negotiate settlements, but really the vast majority of cases, we're talking junk debt buyer cases, these are cases we want to litigate. These are cases we want to defend through trial, because you're going to win and you're going to maybe not in municipal court, maybe you might need to appeal to the Court of Common Pleas and tire them out there, but you can provide total relief without having to actually negotiate a settlement. Of course, if your client really wants to settle, obviously it's their choice to do that. And as Alfonso, I think earlier mentioned, sometimes you just need to educate clients a little bit, because there's so much shame tied up in debt, and people may have just this instinctual response of, I want to pay them, And sometimes you just need to take a little pause, take some deep breaths, and explain to the client that they actually have defenses, and we want to make sure that any agreement that they're entering into is with the proper party for the right amount. If a client does want to settle the matter, a couple of things to consider. Next slide, please. One, as we talked previously, you want to make sure client actually has the ability to repay. Time and time again, I have clients who say, I'll pay $100 or $200 a month. but they're living on $780 in SSI income every month. They do not have $100 or $200, and just taking a moment to kind of walk through a budget with them can be helpful. Generally, we avoid open-ended payment plans with interest continuing to accrue. Instead, just set a lump sum amount and affordable payments. Always, 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 always do this through a settlement agreement. That's just a payment plan, not agreeing to have a judgment be entered against them. And typically in a settlement agreement for payments, I would also add a provision that requires the plaintiff to give an opportunity to cure in the event the defendant misses a payment or is late with a payment. Next slide. Oftentimes I would draft these yourself. And if you need a sample, we're happy to provide them. Do not ask for something from the other side. They will send you a release, a broad release for future claims. Any other debts will be covered as well. Just do the settlement agreement yourself. I often require them to warrant that they're the actual holder of the account. One thing to be aware of is if you are negotiating a reduced payment amount, that may be considered forgiveness of debt. For example, if the person's being sued for $3,000 and you negotiate a $500 payment arrangement, that difference can, in certain circumstances, be considered forgiveness of debt that can trigger a taxable event. We're not going to do a tax seminar today, and we're already behind on time, but I just wanted to flag that for you. And oftentimes you can just take care of that by, if true, including in the settlement agreement a provision that this is a disputed debt, and that can give people tools to be able to deal with any potential tax implications. We also try to get, help this be part of credit repair. So asking for a hard delete, having this item removed on a credit report is something that we typically try to get in a settlement agreement. So that's the quick and dirty tips on settlement agreements.
I would just add, sometimes with some of these lenders, you can get the settlement is a forgiveness of like a hardship discharge, and they may want, in that case, a release, in which case maybe we'll look at this. Again, you can point out some things, but I think in those cases, they're likely to want some kind of release. But as long as you make sure it's just as to this debt, I think that I'm more inclined to recommend those, if that's going to be that. And as for the tax consequences in those cases, usually it's not going to be big. But I mean, if you're only getting $780 a month in Social Security, having a $10,000, $5,000 or $1,000 debt forgiveness isn't really going to really lead to tax liability.
And I have settled some of these cases in the past, and another important consideration is if you do enter into a settlement agreement as opposed to a judgment by agreement, say the debt's $7,000, then you agree to settle for $1,000, and there's no acceleration provision, and your client breaches, they'll have a claim for breach of contract on the settlement agreement. So you've essentially reduced the debt substantially, and that's one of the considerations that I use. So I have settled cases for my clients. Sometimes our clients, if they can't pay the debt, well, then the debtor's got to come back and sue for breach of the settlement agreement that the underlying claim was settled. So moving on, I know we're behind on schedule on the municipal court strategies. We've mentioned this before. Show up and defend the case without your client present. This is important, like we said, in those situations where if your client's going to testify that they did make the charges on the card, essentially game over. So you go up on your own, make the defenses, make the plaintiffs prove their burden. A collector is going to be unlikely to prove the case without bringing a witness, and if they don't have the required documents, I think we've covered this ad nauseum before. Bang the drum. It's their burden. If the notice of intent to defend is returned, you have a right to hearing in that day, even if it's in court 5. I typically don't return the notice of intent to defend. Like I said earlier, I have tried to not bring it and insist on a trial that hasn't worked. So just if you want to avoid room 5, you can use those strategies we discussed earlier. Make sure that if you win, there's a judgment entered for your client and against the debt collector, rather than merely a dismissal of the case. I have had, this has happened to me recently. I'll go to courtroom 5, I'll continue it, and essentially I'll show up and I'll be notified by the court officer that the other side has voluntarily dismissed this case without prejudice. that's not ideal. Ultimately, you want dismissal with prejudice. I mean, they're doing that because they know they can't prove the claim and they're trying to keep the claim alive. And of course, as we discussed earlier, if you do lose, you do have that right to a de novo appeal, which means basically nothing that happened in this court matters. Next slide. Use the rules. Rule 109. We discussed Rule 121 earlier, and then there's also Rule 109, which discusses the contents of what they need to put in a complaint. A lot of times it's bare bones and they don't satisfy the rule. They've got to put an itemization of the sums owed with an attached copy of invoice or statement of account. You typically will see invoices. They need a copy of the writing upon which the claims are based. If it's a contract claim, they're often not going to attach the contract. I see it in maybe 50% of the cases. And of course, they need the brief statement of facts, including all the relevant dates, times, and places. So just be cognizant of that. It's another quiver at your disposal. So another arrow in your quiver, I should say, at your disposal. So just keep that in mind. And that's all I have on that issue. Next slide.
All right. On the Court of Common Pleas, I'm just going to really kind of go through this again because of the time. For me, the option is always file preliminary objections. I very rarely reach out to counsel unless, because I know that I'm not going to get an answer unless it's somebody that I've dealt with before, in which case then I might say, hey, this client's only on Social Security. Would you just discharge this? But usually I'm going to fire preliminary objections, and then I might do a settlement letter, like, we'd ask that you forgive this debt, given the client's income. And then I usually count on filing at least a couple of rounds of preliminary objections, and then an answer, and then only depending on who the creditor is, maybe a negotiated payment arrangement. But that's pretty rare in terms of that. So again, we've gone over the Rule 1019 is, agreement, they need the contract. So you have to attach a copy of that. Next slide. Verification. I raise this, but it's always one that's very easily fixed. I'll usually just substitute a verification, but I mean, they're almost always verified by either the attorney, in which case then they'll do something with the party. Sometimes I see a verification that just says by the authorized representative, and I will raise that. There's like a Citibank case that says, they have to state what their relationship, if they're a servicing agent or something like that. Next slide. And again, you always want to file POs. There's always going to be insufficient documentation, and verification usually could be an issue as well. Next slide. Here's some sort of case laws. The POs can establish a very meritorious defense to open the default judgment, and attest to the writings, or the verification can also be a basis as well. Go ahead. Next slide. I love the Stern decision. It really is a great opinion out of West PA that sort of gives the burden of proof, including the contract and all the statements that show how you got from a zero balance to the current balance. Next slide. Again, to satisfy pleading requirements, the contract between the defendant, credit card holder, and credit card is to be attached, along with the contract between the credit card company and assignee. And that means for me the asset purchase agreement if it's a debt buyer, which they never have. Next slide. Again, amended complaint. Some cases you should be aware of. Amended complaints seeking value of credit cards proper when all statements are attached thereto. For example, you might see that with Discover. Like if I raise POs with Discover, I'm usually going to get a stack, but the next complaint is going to have all the statements. And if they're not seeking interest or attorney's fees, there's some case law that says the credit card agreement is not needed. Next slide. Unifund versus Vo. This is a great opinion. 3 rounds of it's always worth. It's definitely in the materials, and it's worth taking a look at, just showing how rounds of preliminary objections can get rid of these cases. Next slide. Filing and answering discovery. So few of you are going to get to this point. I just want to sort of gloss over that. Review the common defenses that we've talked about. Be prepared to go in arbitration. Again, that's very unlikely. And the litigation tactics. Does discovery help plaintiffs prepare? I've never really bothered with discovery in any of the credit cards. I think if I were going to an actual arbitration, I probably wouldn't, because I think it would help them to prepare. I think I would throw the dice and kind of go in cold to the arbitration. That's just my approach on that. Anyone else have anything to chime in on that? All right, next slide. Rules are your friend. Don't be afraid to recheck them. I mean, I don't memorize the rules. Every time I look at a case, I always take a look at the rules and double check and when I'm examining these things. You have, as a volunteer, much more time per client than the plaintiff's attorney does. So it's always worthwhile to go through those things and double check every time. Next slide. Resources. Lelabari?
Yes. So the National Consumer Law Center has an online library where you can access different manuals on consumer protection issues. Their manual related to this debt collection topic is called Collection Actions, Defending Consumers and Their Assets. And that's a great resource on available case law, strategies, things to consider with different type of clients, things to consider with different type of defendants, plaintiffs, and it's very, very helpful. Also, VIP has an online video and slides from a June 2020 training that we did with them, and these slides will also be available online as well.
Quick thing about NCLC, if you are a member of Jenkins Law Library, you have access to their entire library online. It's a great thing for as a solo attorney. My Jenkins Law Library membership was essential because it gave me so many resources, including the NCLC manuals.
And we are here as a resource for all of you. So here's our contact information. If you have any questions, like to brainstorm anything, we are here. So feel free to shoot us an email or pick up the phone.
Thanks very much, everyone. We do have a few minutes left. If there's any questions that anyone would like to ask, I do see a question in the chat that says, are there any tips for dealing with credit unions?
That's when you probably want to settle. They're such bulldogs, you know. When you join the credit union, you're part of a family, everyone's a member, but when you default, they come out. They're probably one of the most aggressive creditors I've come up with is, and generally they're going to have all the documents. So I'm as cordial as possible. They're probably the one I'm most cordial to when I'm trying to deal with.
Any other questions, comments? I know we have a few experienced volunteers joining us today as well. They'd like to chime in on anything. If not, I will share the materials again with everybody that attended today. And of course, the recording of this training and the materials will be available on our website as soon as I am able to do that. So thank you all again for attending. Thank you to my panelists. You all are great as usual. Pleasure to have you. With that, I hope everybody enjoys the rest of their day. Thank you.
Bye all.
Thanks.